Hi, very good morning. This is a very interesting and important judgment of Delhi High Court. The citation is High Vista Buildcon Private Limited versus National Faceless Appeal Center. So, facts briefly, the petitioner filed an appeal before the Commissioner of Income Tax Appeals against the order of the assessing authority. Assessing authority initiated penalty proceedings. The petitioner requested assessing authority to adjourn the uh, hearing of the penalty because the appeal order is pending. The appeal is pending before the Commissioner of Appeals. But during the penalty proceedings, the AO informed the petitioner, your appeal has already been rejected. So there is no need to wait. I will pass the penalty order also. Then only the petitioner came to know that the appeal has been rejected. Appeal filed by the petitioner has been rejected by the Commissioner of Appeals. Petitioner immediately downloaded a copy of the appeal order and filed a writ petition before the Delhi High Court. Nowadays, those who are dealing in income tax, they know the appeal hearings are faceless. But the petitioner made various representations before the appellate commissioner to give him an opportunity to explain the nature of the transactions. Please give me an opportunity by virtual mode or by person. He also made some written submissions, but no notice was given or no hearing date was fixed, and the order was passed. The contention of the petition was a personal hearing should have been given by the appellate authority, either in a personal mode or in the virtual mode. Mere written submissions I have filed, that is not enough to explain the nature of the transactions. So that was the contention of the petitioner. Department said no. Your written submission itself is enough because it is a faceless appeal. So we cannot provide an opportunity of personal hearing or by either personal mode or by virtual mode. Delhi High Court accepted the contention of the petitioner. The appeal proceedings presupposes hearing of petitioner either physically or virtual mode, face to face or with the face of the authority masked or behind the curtain. So if you want to, because it is the department, it seems the government wants to uh, reduce the corruption. So that is why they are saying that it is faceless, faceless assessment, faceless hearing. So if you want to give an faceless hearing, you put either a mask or ask the Commissioner of Appeals to sit behind a curtain and hear the case. Consideration of written submission can in no manner substitute oral or personal hearing. That is the view of the Delhi High Court. In this case, personal hearing or virtual hearing was not given to the petitioner. This led to miscarriage of justice or failure of justice. There are various issues which can be properly explained because it is all accounts. By somebody seeing the written submission cannot understand the accounts. It is easy to reject, but only when somebody explains the nature of the transactions, then only you will understand. So, High Court says there are various issues which can be better explained in personal hearing mode or virtual hearing mode. Mere written submissions are not sufficient for proper adjudication. So the Delhi High Court set aside the order of the appellate authority. So the following directions were given by the Delhi High Court. One, the court ordered the NFAC, that is National Faceless Appeal Center, NFAC, to provide a video conference link to the appellants. Whoever files an appeal, you give a video conferencing link for personal hearing or virtual mode of hearing. If that is not available, CIT appeal was directed to provide opportunity by way of Zoom Cisco WebEx or Google Meet or any other virtual mode. So you yourself give the opportunity of personal hearing. Then, two, the penalty order that was passed by the assessing officer was set aside because naturally the appeal order has been set aside. See, CBDT was directed, third point, CBDT was directed to provide facility of video conferencing within 3 months to all the appellants, whoever is appellant. I think this judgment is very useful because I was also thinking how, by way of written submission, how can they say no personal opportunity of hearing can be given? So that many things cannot be explained uh, in appeal hearings. So it's a very good judgment according to me. Uh, I don't know how the income tax will view this thing. So whether masking the commissioner or putting a curtain before the commissioner, will it help? Because nowadays technology is so much, they will easily identify the commissioner, who is the appeal commissioner, and what the government wants to avoid. Will it eventually happen? That is also a question to be looked into. That's a anyway. It's a good judgment. Thank you very much. Have a great day. Bye.